I think it's important to recognize that the argument that Tinsley is raising here about the substantial effects test is precisely the argument that the court rejected in the SNPCO case, wherein the court said that the lower courts had been erring by focusing chiefly on whether the challenged ordinance substantially affected the use of property without analyzing the extent to which the challenged ordinance was so closely related to the city's zoning plan that it should be considered tantamount to zoning. Courts must first determine whether the challenged ordinance relates to the city's general plan of zoning. Then and only then, those are the key terms, then and only then may courts ascertain whether the ordinance results in a substantial interference with the use of land. Both parts of the test must be satisfied for a challenged ordinance to be held tantamount to zoning. We think that addresses the whole issue with the substantial effects test in this case. We pointed to the Goodell case from Iowa, which...
So if a county does not have a comprehensive zoning plan, it's just free rein, cannot apply.
We think that that is a fair reading of SNPCO. If the court isn't, inclined towards that reading, we think it's important that the court recognize and reaffirm that the hallmark of zoning is not land use regulation, nor is it location-based regulation as kind of an abstract principle. It is the drawing of fixed lines on the map that do not depend or move or change based on how anyone else is using their property.